Welcome back to This Week in Immigration. I'm Jordan LaPier. On the program this week, the Trump administration seeks to curb asylum claims at the southern border. Immigration agencies step up expedited removals. And as Congress heads toward August recess, an immigration report card. Before we get started, please remember you can subscribe to this podcast on Apple Podcasts, Google Play, Stitcher, Spotify, or wherever you get your podcasts. And if you leave a review, it'll help more people find our show. You can also stream This Week in Immigration on our website at bipartisanpolicy.org/podcasts. And as always, check out bipartisanpolicy.org/immigration for more information on the stories we discuss here on the show. All right, here with me today are Theresa Cardinal Brown, Director of Immigration and Cross-Border Policy. She's on Twitter at BPC_T Brown. Hi, Theresa.
Hey, Jordan.
Cris Ramón, Senior Immigration Policy Analyst on Twitter at CRamónBPC. Hey, Cris.
Hey, Jordan.
And Laura Hall, Senior Manager at BPC Action on Twitter at LHallDC. Hey, Laura, welcome back.
Hi, Jordan. Happy to be back.
Earlier this month, the Trump administration proposed new rules that would bar most migrants from claiming asylum at the U.S.-Mexico border if they first traveled through another country like Guatemala or Mexico. Immigrant advocates and civil liberties groups quickly filed suit to halt the action, but last week a federal judge allowed the rules to stay in effect pending further appeals. So let's start by breaking it down. What is the Trump administration attempting to do with these proposed changes to asylum rules?
So this regulation is very similar in intent and goals to the regulation that was issued last year that purported to bar asylum applications from anyone who appeared between the ports of entry. It relies on a similar section of law, a section of law that allows the Attorney General to add additional bars to eligibility for asylum as long as they're, quote unquote, consistent with the rest of the asylum statute. And so this regulation was put in place as an interim final rule, which with immediate effect. There is still an opportunity for notice and comment, but the rule will be in effect while those comments are being received. As you mentioned, there were two lawsuits filed, one in the D.C. District Court and one in the Northern District of California. The D.C. Court just recently ruled, as you said, that they would not issue a temporary restraining order or an injunction against this while the case moved forward. As of this recording, the California case has not issued a decision on the injunction or restraining order. That could come before this podcast is released. We don't know. But the upshot is that in the meantime, any new people who are encountered at the U.S.-Mexico border who wish to claim asylum would go through a credible fear screening process. But as part of that process, if they have traveled through another country, this bar to asylum would apply. They do have the ability to apply for a lesser form of relief than asylum, something called withholding removal, but the criteria for that and the level of proof for that is much higher. In practicality, since almost everybody who's arriving at the U.S.-Mexico land border, other than Mexicans, has traveled through another country to get to the United States, this would actually prevent the majority of people arriving right now from claiming asylum in the United States.
What has been so controversial about this proposal?
Well, certainly asylum and human rights advocates say that this is a violation of our existing immigration law, that it is not consistent with the rest of the asylum rule to say that people are barred from applying for asylum. In fact, the asylum legislation as it stands now does say that anyone who arrives, whether or not at a designated port of entry and regardless of how they got here, is eligible to apply. Also, that this could potentially result in people who would otherwise apply from asylum being returned back to the country they're applying for asylum from, and that would violate not only our domestic law but our international obligation not to send people back to countries where they might face persecution, so-called non-refoulement. So there's a lot of opposition to this on the grounds that it does violate our existing law and our obligations under international refugee treaties.
And is that the substance of the arguments that litigants are making in court to try to get a stay put on these rules?
Yeah, that's partially. They're also arguing against the implementation of this as an interim final rule, that it should have been out for notice and comment. I think the primary arguments, though, are that it's inconsistent with existing asylum rules. We have had additional bars to eligibility for asylum, but we have never before had something like this that would actually prevent people from even applying for asylum. And I think that's one of the issues at play here.
So you mentioned the abandoned effort from late last year to restrict asylum for migrants who enter between ports of entry at the border. What's different about this proposed rule, or what's sort of similar in the approach between these two?
Well, they're relying on some of the same authority, this authority in law that allows the Attorney General to add additional bars to asylum. The difference in the last one is that they also had this requirement that it was unlawful to apply, or they were barred from applying for asylum if they arrived between ports of entry and the president has issued a proclamation under his broader authority to prevent entry to the United States that said you can't enter this way. So it was sort of a shoehorning of two different authorities. There's not a presidential proclamation or any presidential action in this particular rule. It relies strictly on this authority of the Attorney General. In the rulemaking, the administration argued that the reasons that it was making this rule, one is it clearly talked about the need for preventing migrants from coming to the border. It also talked about putting pressure on Mexico and Central America for asylum agreements that we're trying to get there. But most and foremost, as you said, it's another attempt by this administration to somehow shut off access to asylum for arriving migrants as a way of preventing them from or deterring them from coming to the United States.
You mentioned those international agreements. So, Cris, I'll turn to you. As this new rule is coming into effect here, the Trump administration's efforts to sign what's called a country of first entry agreement with Guatemala ran into some trouble. What happened there?
Yeah, so this is interesting because we had a little bit of international intrigue around this, which doesn't happen often with immigration policy. But basically what it came down to is that the Guatemalan government, at least the president of Guatemala, Jimmy Morales, was ready to sign this agreement, but the Guatemalan Constitutional Court actually ruled against his capacity to be able to do so because he did not consult with the Guatemalan legislature. So in terms of a little bit more background, over the last couple of weeks, we've been hearing a lot of reports about an impending country of first entry agreement that was going to be signed between Guatemala and the United States. And the idea is that if migrants from El Salvador or Honduras entered Guatemala, they would have to apply for asylum there under the auspices of this agreement. Now, we started hearing a lot of news that, that the negotiations were picking up, that Morales was really on board, that there were discussions. The Guatemalans were trying to let on, well, we're not really sure if we're signing this agreement. We have some principles that we're sharing with the United States. But then finally the news broke that Morales was going to be traveling to the United States to sign the agreement. And then what happened is about 2 days before he was set to travel to D.C., all of a sudden the trip was canceled and everybody's sitting around saying what happened. And eventually news about this lawsuit that led to the Guatemalan Constitutional Court came out and basically said, yeah, this has been the president cannot do this without consultation of the legislature, and that's what ended up happening. So I think the big takeaway from this incident is really that the domestic politics in these countries is really, really important. You can't discount what can happen in these countries. And this is important because Mexico is also a country that the Trump administration wants to sign one of these agreements with. And we're not sure really where these conversations are, but it's important, I think, for anybody to think that if the Trump administration thinks they can just sign this without any other considerations for the domestic political situation, they're going to be in a world of pain.
One other thing I just want to point out, that these agreements that the administration is trying to sign with Mexico and Guatemala, people have been calling them safe third agreements. That is not what they are at all. There's no requirement that they demonstrate that they're a safe country. And most safe third, the one existing safe third country we have with Canada, it's a reciprocal agreement. That is, either country can send back to the other country migrants who apply for asylum there if they came from the other country. These would be one-way agreements. In other words, the United States could send back migrants from anywhere in the world who had been in Guatemala on their way to the U.S. border. This is huge. It doesn't necessarily say that they would have to apply in Guatemala or that Guatemala would have to accept those applications, but it essentially says that we could deport migrants from anywhere in the world back to Guatemala if they came to the U.S. border, and Mexico is similar. So it's interesting if you combine that with the rulemaking that happened. The rulemaking barring asylum for people who traveled through third countries was issued the day after this Guatemalan deal went south. So clearly this had been in preparation for quite a long time, and was the administration say, okay, well, we can't get an agreement, we're going to unilaterally essentially do this. this does not allow them to send people back to Guatemala who aren't from Guatemala. They'd be returned to their home countries. But it's essentially a similar process in saying, migrants, if you haven't applied first in the country that you try to get to the United States through, then we can deny you here. So it has a similar impact.
I think the one thing to conclude with this also, and I've been writing about this for some time, is that these agreements, really just don't do a good job in managing the flows of individuals seeking asylum, especially when they're in large numbers. What you saw in the European Union, for instance, that they have a regional agreement, a country of first entry agreement across the whole EU, that you saw the way it managed the European refugee crisis. It just managed it really poorly, largely because during the initial stages of the crisis, a lot of the migrants that were entering the EU and trying to seek asylum in other parts of it were getting kicked back to Hungary and to Greece and to Italy, and those countries just didn't have the capacity to receive the large number of migrants. And so I think that if you try to sign an agreement with Mexico or with Guatemala in the region, you're going to just see the same problem reproduce itself. So I think that's really one of those things to consider, is that if you have this plan in place, it may not actually deal with the immediate crisis.
So you mentioned the EU. How common are these country of first entry agreements around the world?
So this is, I think, in my opinion, is just basically the most common form of agreements for managing the movement and sort of the reception of asylum seekers around the world. This is pretty much the common model. And there's variations of this. So there are bilateral agreements, like the Safe Third Agreement with Canada and the United States. That's a reciprocal agreement. But there are also kind of bilateral agreements that are non-reciprocal. So Australia has some of these agreements with some countries in Oceania and the Oceania region that those individuals have to take back the asylum seekers that come to Australia via boat. They have to take them and process them. So that's a variation that we see that, and I think that's what we might see with Guatemala and Mexico. But then there are multilateral agreements like the Dublin III regulations in the EU, but that's pretty rare. That was largely a feat because of the European Union. It's a large geopolitical union, and they wanted to have a common set of policies. So there are different variations, but this is probably the most, this is the most common way of dealing with the management of reception of asylum seekers.
So where do we go from here? You sort of previewed that the administration is not done negotiating with Guatemala and Mexico on these agreements.
So with Guatemala, President Trump came out on Twitter and said that if they didn't sign this agreement, or they didn't try to come to work with the United States on this issue, that he would impose a tariff on Guatemalan imports. Once again, the domestic politics of this is going to make this very difficult, because clearly the Constitutional Court of Guatemala said you cannot sign this without consultation. So we're going to see where this goes. But this is one of those instances where the president wants something that I think domestically in Guatemala he cannot get. With Mexico, there has been progress with Mexico's management of the individuals arriving at its southern border, with clamping down on the movement of migrants. And they've started saying, okay, look, President Trump, you threatened us to hit us with tariffs unless we clamp down on migrants. We're upholding our end of the bargain. Let's keep seeing where things go. The question is, if the number of migrants entering Mexico and arriving at the U.S.-Mexico border increases, the question is whether or not President Trump will then say, you know what, it's time for us to sign a country of first entry agreement with Mexico. And I think we're not there yet. I think we'll probably get a better idea if something's going to be signed by this fall, when you start seeing, historically, when more people start arriving at the U.S.-Mexico border.
All right, after the break, expedited removals and ICE raids. The Trump administration this month also introduced guidelines that would allow immigration authorities to deport more people through what's called expedited removal. That process has been on the books, but these new guidelines aim to greatly expand when and where it could be used. Now, that news came on the heel of some much-publicized potential raids by immigration authorities in major cities as part of a strategy to deal with the border crisis. What exactly does expedited removal mean, and how has it been applied in the past?
So expedited removal, as you said, is a process that allows for more rapid deportation of migrants who are either in the country without authorization or have overstayed a visa. It has been in statute since at least the mid-90s, but it has not been fully implemented. As created in statute, the authority could be used for anyone who arrives to the border or anyone who is apprehended inside the United States who entered without inspection somewhere between the ports of entry, for example, and has been in the country less than 2 years. Until this most recent notice was put forward, it was primarily used for people who entered and were apprehended at the U.S.-Mexico border or at the border of the United States. So somebody who was apprehended trying to come in either between the ports of entry or somebody at a port of entry who was concealed or who tried to enter through fraud or misrepresentation. It is an immigration deportation. It's considered a formal deportation, so it carries with it immigration consequences such as bars from return to the United States. And it is an option for U.S. immigration officials to do instead of putting somebody in formal removal proceedings that would go through an immigration judge. As I mentioned, it had previously only really been applied to people arriving between ports of entry and to people arriving at ports of entry. There was an expansion to people who were apprehended or arrived by sea in the early 2000s, about the time of the Haitian migration, but it had never been used inside the United States until the notice that came out this week.
So you're sort of leading into the next question, which is how exactly would these new guidelines change the scope of this expedited removal?
So again, previously, mostly it had been used at the border. There was authority to use it within 100 miles of the land border. So, for example, Border Patrol checkpoints that were existing in that time frame, in that location would use expedited removal for migrants that they may have apprehended. But it was not used generally throughout the United States. And again, this now would allow, for the first time, Immigration and Customs Enforcement agents who arrest migrants inside the country to use it. Primarily, this has been a tool of CBP and the Border Patrol. This would be the first time Immigration and Customs Enforcement agents would be able to use it on a broad basis.
When you're talking about expedited, what kind of time frame are we looking at?
So the decision for expedited removal can happen fairly quickly. The process involves, one, if the arresting officer believes that you meet the criteria for expedited removal and that you entered without inspection and you have not been in the country for more than 2 years and you cannot prove otherwise, then they would put you in expedited removal proceedings, which is basically a paper-based proceeding. It has to be signed off by a supervisor, but not higher than that within the department. And they can detain you in ICE detention facilities until they can arrange for your removal from the country. So this could happen in a matter of days or weeks, depending on getting travel documents. The only defense against this really is the asylum process. If you express a fear of going back to your country, then, as we talked about at the border, you have the right to have an interview with an asylum officer to determine whether you have credible fear. That could put you in asylum proceedings before an immigration judge, but otherwise you'd primarily be removed from the country at most a matter of weeks rather than months or years.
What's the Trump administration's goal in pursuing this change?
So according to the notice, one fundamental goal is to deal with their concerns about detention space in the United States. So Immigration and Customs Enforcement runs detention centers both for families and for single adults, men and women. Those detention facilities have been full and are over capacity due to a couple of different factors. One is the continuing arrival of migrants at the U.S.-Mexico border. CBP has placed a priority on ensuring that those who are not part of family units, which still are about 40 to 45% of arrivals, are placed in expedited removal, detained and removed as quickly as possible. That detention process is an ICE process, but ICE's facilities to detain those people until they can be removed have been limited. And so CBP is very concerned about having to release adults into the country as well as families. In their minds, that would be essentially admitting defeat at the border, that we cannot prevent anybody from coming in. Adding to that, ICE has been arresting more people inside the United States. We'll talk about the much publicized raids in a minute. But over the last several years, they have been increasing the number of people they've been arresting within the United States. And most of those people are also detained until their immigration hearing. So by using expedited removal, basically ICE is able to move people out of their detention system faster, open up more space for more border arrivals to come in.
I think you can anticipate that immigration advocates are probably not responding positively to this. What steps are they taking? What ability do they have to try to challenge this?
Well, there are some court challenges pending. I haven't seen whether any suits have been filed as of yet, but we know that many are about to be filed on this. Look, expedited removal as a process in and of itself has been challenged in courts before and challenged how it's been implemented before and has generally been upheld by the courts. There have been various aspects of how it's been implemented that have been challenged and or overturned by the courts, but the authority itself has been pretty much sustained by the federal courts. And I think the question here is whether or not sufficient notice was given, and a lot of this will come down to how it's being implemented. How are the decisions being made? How will ICE determine whether or not somebody entered without inspection or has been here less than 2 years based on whatever the migrant can produce at the time of their arrest? Would they give them an opportunity to provide additional information? So a lot of those questions are being raised by immigration and human rights advocates. The other concern is that would this be used very broadly? If it can be used anywhere in the United States, would they go around just sort of asking people randomly if they have immigration papers and the concern about profiling? I'm not sure that's going to be an extensive concern. As a practice, ICE does not usually just randomly go around talking to people and asking them their immigration status. ICE usually operates in planned enforcement actions where they're targeting a particular person. They may, as a collateral or a consequence or along that, if they encounter other migrants, talk to them and interview them about their status. But it is not, in the past at least, been a large practice of immigration customs enforcement to sort of go around looking for people who might be undocumented in the country. And so I'm not sure how realistic that particular concern is, but there are concerns about how it will be implemented, what recourse migrants might have, and there probably will be some people wrongly apprehended and put into this process.
All right, let's change gears then and talk about the threat of so-called ICE raids in major cities around the country. The suggestion was that those were to have happened earlier this month, but acting ICE Director Matthew Albence told reporters last week that only 35 people were arrested in those raids. What happened?
So if we remember, around the time of the last Democratic debate, the president tweeted out that ICE would begin rounding up families inside the United States for deportation. There was going to be a massive set of ICE raids that were going to happen, I think, that following week. And then later he, after some concern and pushback, I think, from within the government over publicizing that, pulled back and said, okay, well, now it's not happening. And they were postponed for a couple of weeks. But they were supposed to have happened in the past week. The president again tweeted, starting Sunday, we will see this. The reality on the ground was very much different. And again, because there'd been notification of this, reporters were out, immigration advocates were out, and all of the major immigrant centers looking for this ICE activity. And aside from a few incidences, there was not a widespread ICE activity. And as you mentioned, when the acting director of ICE gave his report this week, he mentioned that a total of 35 family members were arrested. Now, there were 35 people arrested, 17 or 18 of whom were family units. So relatively small. But he also indicated that in light of all of the publicity surrounding all of this, ICE had actually decided to scale all this back, and that this was not a one and done, that this was just a beginning, that they would have ongoing operations that would continue. And again, that's more consistent with how ICE operates generally. Let's not forget that ICE conducts operations constantly in this country. Not all of them could be considered raids, and that's a term that they don't like to use. They call them immigration enforcement operations. But they happen usually with a list of targeted people that they're looking for after a period of investigation and surveillance of the targets to make sure that they know where they are and that they have a place they can apprehend them in relative safety for the officers and the community around them. That is generally how they would like to work, and this sort of went very much against their usual operational mandate. So the fact that they sort of turned this into an ongoing operation, I'm not terribly surprised about.
Yeah, what was interesting about this as well is, the president, his modus operandi in a lot of ways that he's been conducting his policy is trying to publicize big wins to sort of demonstrate to his base and other individuals that he's making gains, including, with immigration. And so I think the way that he sort of publicized this to try and make it seem like he's actually doing a lot on enforcement ultimately actually ended up undermining and kind of being counterproductive in these goals. The other thing to remember with this is that he threatened Democrats to carry out these actions unless Democrats came to him to talk about asylum reforms and restrictions. And I think, once again, the fact that he publicized it made it a lot harder for ICE to actually carry through with these actions. And so as a result, his threats towards Democrats, it was a little bit harder for him to actually go ahead and enact them. So I think that it's sort of this need to sort of make a much more public demonstration of force that in some ways actually wasn't that helpful. And that sort of the reporting indicated that ICE was a little bit not pleased with the fact that a lot of this was being discussed in the open air when they just simply want to do their work without any type of publicity and just simply to be able to do their mission.
Yeah, it certainly didn't bring Democrats to the table, but it got a lot of Democrats and immigration advocates to go out publicly with Know Your Rights campaigns and to tell immigrants how they could avoid being arrested by ICE. I mean, this is kind of unprecedented, and there's some commentary about this to think about. We've been talking a lot over the last couple of years about the idea of sanctuary cities and the sanctuary movement and how it's grown into abolish ICE. Now you have a situation where a nationwide enforcement action to enforce the law, and you can debate, and probably it is good to debate whether or not all of these individuals had full due process and all that stuff. But essentially, you have a widespread effort by members of Congress, by community leaders, by local leaders and immigrant advocates to prevent a law enforcement agency from carrying out its duties on a public national scale. This is kind of unprecedented, and for some Republicans who are trying to paint Democrats as against the enforcement of immigration law, this does play into that. But it's really setting up an immigration debate that is fundamentally about whether or not we should enforce immigration law at all, and that's a very, I think, unprecedented in the level and scale we're talking about. And two, that's a very interesting place. It's a part of the immigration debate that we haven't really talked about a lot, except on this sort of, are we giving up on enforcing immigration law totally, or are we enforcing it to the nth degree? It's probably going to generate an awful lot more policy conversations in this country about what enforcement of immigration law means. What it means for communities, what it means for individuals, what it means for migrants, but also what it means in terms of the integrity of the system, and what is the role of the federal government in enforcing immigration law. Ultimately, this falls to Congress to fix. And again, we come back to this kind of theme a lot, that Congress's failure to pass new immigration laws, to set the standards for enforcement for the executive branch, has meant that the executive branch and the rest of the country are engaging this debate without them. And that's fundamentally not going to solve things very clearly on a nationwide basis.
All right, when we come back, an update on legislative action as Congress gets ready for August recess. Finally, Congress's August recess is just around the corner. What's been done on immigration so far this year, and what's left for Congress to tackle? Here's where I'll bring in our legislative guru, Laura Hall. Hey, Laura.
Hi.
Laura, walk us through the legislative action on immigration so far this year. What are some of the major bills that have been introduced, and have any of them made any strides toward becoming law?
So there have been several bills introduced, and some of them have become law. Many of them have not. I think the biggest thing that is now law is this supplemental spending package to kind of tackle the crisis at the border that we've been talking about for several weeks now. That was debated a couple weeks ago and signed into law by President Trump. It provides $4.5 billion in funding for the crisis at the border, so some of the facilities and things like that. It was a more moderate piece of legislation at the end of the day. There was some debate back and forth in the House about whether or not to kind of give President Trump and his administration what some in the more progressive wing of the Democratic Party saw as kind of free reign and control over this money, or should they scale back and, kind of put a little bit more stringent oversight requirements on it. At the end of the day, the more moderate bill that passed through the Senate ended up going through the House as well, and the president signed that. So that's one thing that actually kind of got signed into law in the immigration space. A lot of the other things have made some progress, whether it's hearings, whether it's moving through the committees, whether it's moving through one branch of Congress. The DACA and kind of TPS debate happened in the House. It hasn't happened in the Senate yet. So that's one piece of progress that's been made on the Hill, but hasn't yet made it to the president's desk. The other big funding piece, the DHS bill, had no progress so far. That's kind of been a sticking point for ever since President Trump's been in office. He sees that as a great vehicle to further push for his wall. So that's something that probably we'll see a little bit further down the road. Is that's not something that I think Democrats are eager to take up right now.
So is that the only must-do on Congress's agenda when they come back from August recess as far as immigration is concerned, or are there other priorities on the docket?
So I think they do have other priorities, and I'm not even sure I'd say that's a must-do because it could always be subject to a continuing resolution, or you can kick the can further down the line. I think the closer we get to a presidential election year, this is an election year where a good portion of sitting senators are also running for president. And, what do they want to vote on? What votes do they want to take? So that's something that as you get closer and closer to 2020, some of these votes, unfortunately, they might be punted. You might not take them. You might see a continuing resolution. You might kind of see Congress backing off a little bit. So the definition of must do isn't what a layperson would think of as must do.
What has been standing in the way of greater action in Congress this year? Are there any factors at play that are different from what we've seen in the past, or is it just the run-of-the-mill dysfunction?
I think some of it's more of the same. I think this crisis at the border is heating up passions and inflaming things on both sides of the aisle. I think that there is no doubt that seeing children in some of these facilities certainly was very upsetting to many people. I think it's caused people to kind of dig in on either side. This is something that President Trump has used over and over in his rallies and in campaign events to fire up his base. I think the Democrats are doing that on their side as well. They're just coming at it from completely different perspectives. This is an issue that more and more is getting pulled to the extremes. I think there's still many places where there are moments of connection and common ground and places to move forward. That's not always the sides that are shouting the loudest.
I just want to add that there was a small hope of bipartisanship in the House. They passed one bill on legal immigration, the Fairness for High-Skilled Immigrants Act, that would adjust the per-country limits for employment-based immigration and family-based immigration. That was passed on a suspension vote in the House, which requires 2/3 to pass, and it was a very strong...
And it's a voice vote, too. So
it's a very strong bipartisan vote there. So no idea whether that's going to come up in the Senate. But that was a very narrow, tailored bill. It was bipartisan on its introduction, and as this co-sponsorship went through, it did go through committee and had amendments considered. It was, other than the suspension vote on the floor, it was pretty much regular order, which is, a light in the darkness, I think.
Yeah, but to my point earlier, that's something that not a lot of people know about, So it's not something that's being shouted about as much as the extremes. So there is some reason for optimism, but we just got to break through the rest of the noise.
Yeah, and I think that that's sort of the untold story about this is that for a long time, when we've ever thought about legislative action on immigration, we've always thought about these broad immigration reform bills. But I think what the reality of the situation is, and I think maybe Congress recognizes this in a way, is that really those small tailored bills might be the only way of moving forward on anything related to immigration. And even, among those, the fact that even like the Fairness for High-Skilled Immigrants Act was actually able to be passed among several that have been introduced this year, doesn't really present a whole lot of hope, even though that is a small ray of hope of getting past the impasse that Laura's talking about. And it's just one of those things that just simply the polarization that you see in Congress has been the major impediment with this.
And that's a good point, Cris. The last time comprehensive immigration reform was discussed was 2013, 2014. A third of elected officials are new. We're not there for 2013 and 2014. That's a huge amount of folks that need to get educated on all aspects of what might go into a comprehensive package. So there's...
And I think the tone and tenor, as you said, of the immigration debate has shifted
dramatically
so much since those years that, as you said, it's made some of those conversations harder to even have, much less come to agreement.
Or people have shifted their own positions. I mean, for instance, not to single them out, but Marco Rubio, for instance, who was part of the Gang of Eight that helped pass S-744 in 2013, kind of has been missing in action on immigration, has been as quiet. But not to single him out, but that's just an example of somebody whose position has shifted over the years.
Past champions of bipartisan immigration legislation have not even introduced similar things. So, for example, we were looking at what bills had been introduced on legal immigration, and surprisingly, we found that there have been no bills introduced on H-1Bs. H-1Bs is like the number one high-skilled visa. There's been a lot of efforts to try to reform that program or change the caps over years. Usually there's perennial bills that are introduced every year to try to address that. And we don't have any standalone H-1B introductions. We have a couple of amendments to other things, but that's to me unusual. So some of those past champions are not even looking to do the things they've been working on in the past. So again, I think the tone and tenor has shifted, the tension being just sucked up by what's happening at the border. The fights over border wall money and DACA are just taking up all the oxygen in the immigration debate. But what we'd like to try to do, and hopefully by talking about it a little bit here, is help people interested in immigration to think about what are some of the smaller things that might still have a chance, and how do we get more attention to them, as you said, Laura.
All right, well, there's so much more that we could talk about, but I think we should leave it there for this episode. So Theresa, Cris, Laura, thank you for joining me, and thanks to you all for listening. We will be back in 2 weeks as always. In the meantime, please take a second to find us on Facebook by searching Bipartisan Policy Center, or on Twitter at BPC_bipartisan. And don't forget to subscribe and leave your feedback on this podcast on your favorite podcast platform. Just search Bipartisan Policy Center. This episode of This Week in Immigration was written by Cris Ramón and myself and produced by Yafat Tawahara. That's all for now. Join us again next time on This Week in Immigration.